Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about late disclosure. Cases that should have gone to the Supreme Court of Canada, but didn't. In the case of Mr. Umiyadi, he was provided late disclosure in the middle of trial of significant evidence that actually changed the defense strategy and had an impact upon whether or not there was an alternative suspect or suspects in his case. He was charged with importing drugs into Canada using the mail, and there were other individuals who were alleged to have been calling the Postal Service box office company that were looking for the packages that Mr. Umiyadi was alleged to have been importing into Canada. At trial, after this evidence came out, unbeknownst to him, he argued that his right to a fair trial had been compromised and asked the judge to declare a mistrial. The judge declined and instead permitted him a series of different remedies, including allowing him more time for cross-examination, adjourning the matter, ordering disclosure of the additional material, and allowing the Crown to withdraw a charge that related to some of the new information that had been obtained. This case raised very important issues for the Supreme Court of Canada to consider in relation to the remedies for non-disclosure or late disclosure. While the Supreme Court of Canada has considered these issues in the past, it hasn't considered them in the particular circumstances of a non-police witness raising information mid-trial that was unknown to an individual. And that changes the landscape, particularly where it reveals other sources of investigation or opportunity for investigation. And the Supreme Court of Canada hasn't considered the significance of late disclosure remedies, and in particular remedies that allow for further opportunity to prepare for cross-examination or adjournment of the trial, as they pertain to arguments that might be made in relation to Jordan and the time to get a trial heard within a reasonable time. If the remedies are at odds with the principles expressed by the Supreme Court of Canada in Jordan, then the Supreme Court of Canada ought to have taken the opportunity to explain how these two rights that individuals have, the right to be tried within a reasonable time and the right to fair and full and frank disclosure, exist in conjunction with one another when the remedy might compromise the other right, and the right for one may compromise the remedy for the other. Unfortunately, the Supreme Court of Canada didn't see the significance of the crossover of issues at play here, despite the fact that the existing jurisprudence about late disclosure or mid-trial disclosure has not dealt with it since the Jordan regime was established. Hopefully, the Supreme Court of Canada gets another opportunity to consider how these issues pertain to one another and how the issue of remedy for problems with respect to disclosure factors into the considerations in a Jordan analysis, and how a Jordan analysis factors into remedies for non-disclosure. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.